session chair for today is Dr. Prabhash Ranjan. Dr. Ranjan is the Senior Assistant Professor of Law at the South Asian University. He's been a Chevening scholar and a visiting fellow at the Lauterpacht Centre for International Law, University of Cambridge. He's also been a visiting scholar at the Brookings India and Transnational Summer Law Institute, fellow at the King's College London. Dr. Ranjan teaches and publishes in the area of international investment law and world trade law. He is the author of the book India and Bilateral Investment Treaties, Refusal, Acceptance, and Backlash. The book's been published by Oxford University Press. Dr. Ranjan has also published several papers in various international journals, and he regularly publishes an opinion piece in various newspapers like the Hindu and the Hindustan. It's an honor to have you here, sir, and I request you to please address the participants here today.
Thank you very much for that kind introduction. I'm extremely grateful for this kind invitation. Let me begin by thanking Professor Subramanya, Professor Sandeepa Bhatt, and of course, I'm very delighted to be part of the same session as Professor V.G. Hegde. My gratitude to the School of Legal Studies at CMR University for this opportunity. I'm going to talk about a topic which is very, very important and very relevant as we speak, especially at a time when the second wave of COVID-19 has struck India very badly. And this pertains to continuing from where Professor Hegde has left, pertains to the TRIPS agreement of the WTO. As you might know that India and South Africa have made a joint proposal at the WTO. And under this proposal, they have requested for a waiver from the implementation, application and enforcement of certain provisions of the TRIPS agreement. Now, the objective behind this waiver is largely to free up countries from enforcing intellectual property rights, especially when it comes to vaccines and drugs for the treatment of COVID-19. The idea behind the waiver is that if countries are freed up from enforcement of intellectual property or grant of intellectual property, especially patents, then that would facilitate the production of vaccines and drugs that are needed to combat COVID-19, and that would also ensure their equitable distribution. Now, this proposal was made in the month of October, and in the last 5 months, the TRIPS Council has discussed this proposal both formally and informally. Now, one can clearly see a divide among the WTO member countries on this issue. While a large number of developing countries have backed the proposal of India and South Africa, the developed countries are not very keen in pushing for this proposal. And one can very clearly identify the reasons behind this. The reason behind this is because, as I see it, because most of the pharmaceutical companies which are manufacturing the COVID-19 vaccines and which may manufacture COVID-19 drugs in future are all based in the West. And therefore, they obviously want to protect the intellectual property of these pharmaceutical giants. Now, my argument is not that intellectual property should not be protected, but my argument is that the protection of intellectual property needs to be seen in the context in which we live today. And the context is a very scary one. The context is of a pandemic in which we continue to live for the last more than 1 year. And therefore, in a situation such as this, is it possible to waive the intellectual property provisions in the WTO, at least for a temporary period, till the pandemic, till we have been effectively able to fight the pandemic or not? Now, this is what I'm going to talk about. What is the most important thing in this? I think what we need to first understand is that, is there a legal basis for a waiver of this kind? I mean, what does the WTO law say about waivers? I mean, is there a provision in the WTO law which allows waiving certain aspects or certain parts of the WTO agreement for a temporary period? Now, this is what I want to talk about largely, and then time permitting, I will very briefly reflect about the merits and demerits of the proposal towards the end. The short answer to the question that I'm posing, that is it possible to have such a waiver within the WTO law? The short answer is yes. If we look at Article 9.3 of the Marrakesh Agreement establishing the WTO, which is also popularly known as the WTO Agreement, this article provides that in exceptional circumstances, and please note these words, in exceptional circumstances, the Ministerial Conference, which is the highest decision-making body in the WTO, may waive an obligation imposed on a WTO member country by the WTO agreement or any other multilateral trade agreement. Now, the same article provides that such a waiver may be supported by 3/4 of the members. So, if there's a 3/4 support of the WTO membership, then such a waiver can be allowed. Although there's a decision that was taken in 1995, and as per this decision, first the countries would like to evolve a consensus, and only if a consensus is not possible, maybe they would resort to voting where support of 3/4 of the members would be sought. Now, the same article, Article 9.3b, further says that if the request for a waiver concerns the multilateral trade agreement given in Annexes 1A, 1B, or 1C, that is, whether it concerns trade in goods, trade in services, or intellectual property, which is Annex 1C, then the request for the waiver should be first submitted to either the Council for Trade in Goods for Annex 1A, to the Council for Trade in Services if it pertains to Annex 1B, and to the Council for TRIPS if it pertains to Annex 1C. The current proposal that India and South Africa have made is being discussed or debated at the TRIPS Council. Now, there's another part of Article 9.4, which is Article 9.4 of the WTO, which says that if the Ministerial Conference decides to grant the waiver, they will have to state the exceptional circumstances justifying the decision and the terms and conditions that shall govern the working of the waiver. And this waiver should have an end date, and it should be reviewed by the Ministerial Conference annually if it is granted for more than a year. So Article 9.4 clearly gives the power to the Ministerial Conference to grant such a waiver in exceptional circumstances, and they have to justify the decision, and they can also attach conditions for the working of this waiver. So if we look at Article 9.3 and 9.4, the term which is very important for us in the present context is exceptional circumstances. What do we mean by exceptional circumstances? Because the waiver can only be given in exceptional circumstances. Now, the WTO agreement, Article 9, or anywhere else in the WTO agreement, the words exceptional circumstances are not defined. There has not been any dispute where the panel or the appellate body has looked into the words exceptional circumstances. So we have to rely on scholarly literature or on the preparatory work or the travaux of the Marrakesh Agreement to explore the meaning of the word exceptional circumstances. Now, the words exceptional circumstances, if we take the literal meaning and we apply the rules of treaty interpretation as given in the Vienna Convention on Law of Treaties, we can safely say that it indicates the power of the WTO's Ministerial Conference to waive certain obligations. In other words, it intends to legalize those measures adopted by a country in concrete situations of urgency that would otherwise violate the WTO law. In other words, the waiver power, which is enshrined in Articles 9.3 and 9.4, this waiver power recognizes that there may be certain exigent situations which may cause hardship to a member country when compliance with the WTO norms may not be feasible. So a country is facing a particular situation, a hardship, where compliance with WTO norms is not feasible. And in such a situation, this waiver, such a situation would be an exceptional circumstance where this waiver can be granted. Now, in such a situation, the WTO as an institution for a temporary period, that is till this exigent situation or till this precarious situation lasts, it should legalize non-compliant measures, which means that even if the country undertakes a measure which otherwise would be incompatible with the WTO agreement, but because of the operation of the waiver, these incompatible measures would be legalized. However, there is one important caution, and the caution is that this waiver power has to be exercised and interpreted with great care, because it should not become an easy escape route for the WTO member countries, or for any country for that matter, which aims to circumvent its WTO obligation. Now, so this is what the law states, that in exceptional circumstances, this waiver can be granted. Now, how has this law operated in the last 2.5 decades of WTO's existence? I will, given the paucity of time, I will focus just on two very concrete examples of waivers which have been granted in the past. And this will help us to understand that whether a waiver can be granted in the current situation or not. So the two examples which I want to talk about is, first example is of what is known as the Kimberley Process Certification Scheme. Now, a waiver from GATT obligations was granted in 2003 to some countries concerning measures they adopted that were necessary to prohibit the export and import of rough diamonds, or so-called blood diamonds, to non-participant countries. So, there was this trade taking place in what were known as blood diamonds, and in order to ensure that this illegal trade does not take place, there was a Kimberley Process Certification Scheme which was adopted. And for the implementation of the scheme, it was possible only if certain GATT obligations were waived for the countries who were participating in this scheme. So the idea behind this waiver was to allow legitimate trade in diamonds to take place, and not to allow trade in conflict diamonds or blood diamonds to take place. And this was only possible if some GATT obligations were waived for countries which were participating in the scheme. So this was the first and the most important example of a collective waiver that was granted within the existing WTO law to a set of countries that participated in this particular scheme. The second example, which is relevant to what the kind of situation that we are facing today, pertains to the TRIPS agreement. And as Professor Hegde mentioned in his talk, this pertains to the problem that a large number of least developed countries, or those countries that lack manufacturing capability in pharmaceutical sector, were facing. Now, within the TRIPS agreement, there are quite a few flexibilities which are available to countries. One important flexibility, as you would know, is compulsory license, which basically means that a country can issue a license to anybody else without the consent of the patent holder for production of a medicine or a drug or any item which has been patented, provided adequate remuneration is paid to the patent holder. But there is a very important provision in Article 31 of the TRIPS agreement, Article 31F, which states that when a country issues a compulsory license, it should be predominantly for the supply of the domestic market, which means that if you have issued a compulsory license, then the drugs or medicine or any other, the product which is being manufactured under the compulsory license, this is predominantly for the domestic market. Now, the word predominantly is not defined in the WTO agreement, but it is generally understood as meaning that you cannot export drugs which have been manufactured under a compulsory license. Now, this flexibility will work well for countries like India, because countries like India have the manufacturing capability in the pharmaceutical sector. But there are a large number of countries in Asia, Africa, Latin America, or in the developing world, which do not have this manufacturing capability in the pharmaceutical sector. And therefore it poses a problem for these countries, that if they have a scarcity of drugs, or if they have a scarcity of vaccines in a situation of the kind that we are living today, then how can they make use of the TRIPS flexibilities? So in order to address this problem, in 2003, the General Council of the WTO adopted a waiver. And what they decided was that they would waive the requirements of Article 31F and 31H of the TRIPS agreement. So 31F is issuance of compulsory license predominantly for the domestic market, and 31H is the provision which requires that adequate remuneration or due remuneration has to be paid to the patent holder. So both these provisions were waived in this 2003 decision by the General Council. Now, the waiver of 31F basically meant that now countries can issue a compulsory license for export of drugs, right? So if say there is a country, in Africa, which doesn't have the manufacturing capacity, India can issue a compulsory license so as to manufacture drugs, which can then be exported to this African nation. So the requirement of 31F has been waived or was waived in this 2003 decision. But this waiver was subjected to several procedural requirements. So I'll just tell you about few procedural requirements. One important procedural requirement is that the least developed country or the country which requests, which needs this medicine or drug, has to notify to the TRIPS Council. Once they have notified to the TRIPS Council, then the country which wishes to manufacture this drug and export this drug will then follow up on that request. Now, when India, in this example, or any other country which has issued the compulsory license to export the drugs, will have to ensure that all the production that is made under the issuance of compulsory license is exported, which means that if you have issued a compulsory license for manufacturing drugs for export, those drugs cannot be used or cannot be sold domestically, right? They have to be exported to that particular country for whom they are being produced. So this requirement and few other requirements, such as the pharmaceutical company has to manufacture only the amount necessary to meet the needs of this eligible importing country. The entirety of medicines produced under this license shall be exported to the eligible importing country. The products manufactured under the license, this is another requirement, they have to be clearly identified as being produced under this arrangement, through precise labeling, marking, coloring, etc. So, for example, if India has issued a compulsory license to any Indian company for making vaccines to be exported to Africa, these vaccines have to be put with separate labeling, separate marking, separate coloring, so that they are distinguishable from the vaccines which are being sold in India. Now, this is the second example of the waiver which was given. Subsequently, this waiver has become an amendment to the TRIPS agreement. But the important point that I want to emphasize here is that given how the law has operated in the last 2.5 decades, the question that we need to answer is whether we are living in an exceptional circumstance. The answer is an unequivocal yes. Today, we are indeed living in an exceptional circumstance. And therefore, under Article 9.3 and 9.4 of the Marrakesh Agreement, a TRIPS waiver can definitely be issued on the request of India and South Africa. And today's pandemic definitely constitutes an exceptional circumstance as it is understood under Articles 9.3 and 9.4 of the WTO agreement. Now, as the pandemic continues to rage, countries will collectively have to find innovative ways to not just increase the production of vaccines, but also ensure their timely distribution at affordable prices, right? So, given the mammoth demand that everybody needs vaccines, and as WHO has said that nobody is safe till everyone is safe, which means everybody has to be inoculated at one point of time or the other. There is a huge need to scale up the production of vaccines. And to scale up the production of vaccines, one impediment, there are several impediments, but one impediment could be enforcement of intellectual property rights. And therefore, in this situation, the requirement to meet stringent IP standards which are given in TRIPS agreement may not be a feasible option. And therefore, I'll conclude by saying that a clear legal case can be made for this collective waiver of the kind that was granted to countries participating in the Kimberley process certification scheme. A clear legal case for a waiver can be made today. And it is important for the developed countries to accept the demand of India and South Africa and of other developing countries and to waive the TRIPS requirements at least for 1 year to start with, and then review the situation 1 year later, whether there's a need for the waiver to continue or not. So within the WTO system, there are no legal impediments on adopting this waiver. The only impediment is the political impediment or the political economy impediment. There is no legal impediment, and a waiver can be granted provided the countries are willing to come together and work on this. So with these words, I conclude my presentation, and I once again thank all of you for this kind invitation.